Good afternoon or good morning, everyone, depending where you are. It's a pleasure being with all of you today, and welcome all of you also to the webinar on the Health Environment Nexus and the systemic implications of environmental crimes. I wish to thank the host institution as well as partners and co-sponsors of this conference, the Cambridge Center for Environment, Energy and Natural Resource Governance, the ESIL interest groups on international criminal justice and health law, the Grotius Center for International Legal Studies, and last but not least, also the platform on international energy governance. Now, let me introduce you also our guests and also the panelists. We're very lucky today. I'm going to start by introducing Professor Jorge Minuales, Harold Summer Professor of Law and Environmental Policy at the University of Cambridge and founder and former director of C-EENRG. We have also with us Dr. Leslie Ann Duvich, who is a senior lecturer in environmental law at the Dixon Poon School of Law, King's College London, and project leader of the platform on international energy governance. And both Professor Minuales and Dr. Duvich will open with few words of welcome the conference. And we will then start and we will have two panels. In the first panel, we will discuss the issue of the Health Environment Nexus. And the panel will be chaired by Professor Gianluca Burci, who is a John Professor of International Law at the Graduate Institute of International Development Studies and former WHO legal counsel from 2005 to 2016. And the panel will host presentations from Dr. Alexandra Phelan, who is Assistant Professor of Global Health Law at Georgetown University, and also Dr. Traleng Mofokeng, who is current UN Special Rapporteur on the right to physical and mental health. Unfortunately, Professor Makan Bengwe will not be able to join us today due to personal and professional reasons, so we're of course really sorry for that. Subsequently, we'll open the second panel, which will instead cover the topic of the systemic implications of environmental crimes. And to discuss this topic, we have with us Mr. John Scallon, CEO of the Elephant Protection Initiative Foundation and former Secretary General of CITES from 2010 to 2018. Professor Tanya Wyatt, Professor of Criminology at Northumbria University, and Professor Daryl Robinson, who is Professor of International Criminal Law, International Criminal Justice at Queen's University, Faculty of Law in Canada. So now we've got really two wonderful panels. Many people also signed up for this webinar, so wanting really to take part in the discussion about this important topic. So also thank you for being here and welcome. At the end of the second panel, we will have a Q&A session of 30 minutes. So feel free to ask your questions in the chat. Also during our panels, we will collect all the questions at the very end or directly intervene live during the Q&A session. So without further ado, I'm now going to give the floor to Professor Minuales and also Dr. Duvich. Thank you.
Thank you very much, Ginevra, and I think it's my turn to thank you for having organized such a splendid event, and also to thank the speakers. I think it's going to be extremely interesting, and it's for C-EENRG one opportunity to make an inroad in the area of health policy and law, although the connection between environment and health is quite obvious by now. In academic institutions, we're still struggling to make it more formally. And I think it's a great initiative that you have been able to put together this wonderful group of people. So my role here is really to thank you and to thank the speakers for their time and their availability, and actually to be all ears, because I'm going to be part of the audience and I very much look forward to our discussions. Thank you very much.
Well, I think it's my turn as well to really thank Geneva for organizing such a topical event, and it's really a pleasure to be there. I thought I would just make a few introductory remarks in the form of two general comments to perhaps try to contextualize a little bit our discussions for today, and perhaps start raising some questions. And one is around the social dimensions of today's discussion, and the other one is around the implications for the clean energy governance. And my comments were inspired while I was reading the presentation of the event that was framed within the context of COP26. It was framed as an opportunity to debate some of its outcomes and start drawing some lessons from the Glasgow summit. And so I was thinking, well, what can we actually learn from the COP for today's topics on health and on environmental crimes, when actually the COP did not mention these topics per se. So if you look at the Glasgow Climate Pact, for instance, it only reasserts the Paris Agreement's preambular reference to a right to health in the context of climate change, and it does not make any reference to environmental crimes at all. Of course, it's not a surprise, given that the UNFCCC has been historically framed in a narrow manner, only interested in the act of reducing emissions, irrespective of contextual considerations, be it health or biodiversity or oceans governance, and without really looking at structural obstacles, and in particular our dependence on fossil fuels. However, we know that the COP is much more than international lawmaking behind closed doors. It's a forum to discuss and advance a wide number of environment-related issues. And I think today's topics are very much developing and at the heart of international lawmaking. And I think one of the advantages is that they have really captured the people's imagination. So what we see with the COP26 is that it has highlighted the complex relationship between, on the one hand, popular protests for more climate action, and on the other hand, negotiators just adopting a business as usual approach and endlessly arguing in closed doors, those that were even more closed due to the COVID pandemic, over technicalities about whether we would phase out or we would phase down fossil fuels and coal in particular. So what we've seen is really a gap between what international law is able to do and what society, and in particular the youth, is hoping to see from international law. And there's also at the same time a real hope that international law is going to solve some of our global challenges with a really high symbolic value assigned to international law. So I think in this context, a civil society initiative to note is perhaps the Global Citizens Assembly that was held at COP26. There's a group of randomly selected citizens that are representative of the diversity of our planet, and that were asked to make recommendations that might influence international climate law around how to respond to the climate emergency. And so these people have been coming from all over the world with very different experiences about the impacts of climate change, about what climate mitigation means. But strikingly, they have made two very interesting recommendations that are relevant for today's discussion. In their recommendations, they talk about the fact that we need to actually acknowledge the impact of climate change on human rights, including on the right to health, and also to recognize a right to a clean environment. And the second recommendation is that we need to recognize a right to a clean, we need to codify ecocide as, I quote, a crime in international and national law applicable to governments and corporations. So I think this example is quite helpful to highlight the context within which today's discussions are going to happen. It is a very different context if you compare it to the environment and trade debate, where the populations are generally quite skeptical of the role of international law. Here we see that we have popular support for development and for the development and consolidation of international law. And I think it should encourage us to think a bit about how this popular appetite for these questions can actually make a difference when we are thinking about the environment and health nexus and about environmental crimes. My second comment is more focused on the question of a clean energy transition, since I'm here representing our initiative on international energy governance. And it still relates to COP26 and to the specific debate that actually captured the media's attention about whether fossil fuel sources would be included in the outcome document, and also a lot of media attention on India's push for watered down language. And it was very interesting to see that these debates were covered live by media outlets. You could follow it on the BBC News or on The Guardian as if you were in Glasgow. So what do this issue actually teach us about the themes of today? Well, I think it's an interesting case study to actually reflect on these two questions. While India was diluting the language of paragraph 36, we see actually that the Supreme Court was calling for a lockdown in the capital of New Delhi, not due to COVID, but due to air pollution. So it highlights dramatically how health is intimately linked to environment. And we are here really pushing the health and environment nexus to its maximum. It's not only a kind of causal relationship between environmental problems and health consequences, but also about the lessons that we are trying to learn and the measures, the policy and legal measures that we are trying to replicate based on our experience of a health emergency. But I think also India's push for some diluted language highlights the development components of our health and environment nexus that we're going to be talking about today. On the one hand, energy access is very much key to health, and reliance on coal in a country with high levels of energy poverty is very much understandable. And access to any kind of energy source will have a positive impact in terms of health services, for instance. At the same time, we very much know the health impacts of fossil fuels on health and on indoor and outdoor air pollution. So we see here that this case is highlighting the inherent tensions between environment, development, and health, and is raising questions also about the implementation of Sustainable Development 7 on clean and affordable energy. At the same time, while states were discussing whether we would phase out of coal and other fossil fuels, we can start thinking about whether this phase out might have positive implications in terms for environmental crimes. If, as the Guardian editorial was arguing, every person on the earth today is living in a crime scene because fossil fuels companies lied for decades about climate change, then will a move towards cleaner sources of energy actually put an end to those environmental crimes, at least as they are related to fossil fuels? Well, I think this transformation also needs to come with a full realization that the clean energy transition also comes with its own risks, and that we might actually be generating new criminal activity that might cause further and different types of environmental and social harms, for instance, as we focus on electric vehicles that rely on mineral extraction like lithium or cobalt, and that might also have an impact on and that might lead to some criminal activities. So I think these are some of the questions that the COP26 can inspire to think about, and that I think the case of India and the global citizens assemblies have very much highlighted the topicality of the two themes that we're going to be discussing today, and I very much look forward to hearing what our speakers are going to share with us today. Thank you.
Thank you, Leslie Ann, for your words, and also, of course, Professor Viñuales, and also for contextualizing really this conference, for reflecting on the results of COP26, and also on energy transition, on the link between health and development. These certainly are all topics that will come out also in our panels. So now I would like to give the floor to Professor Gianluca Burci to open the first panel on the Health and Environment Nexus.
Thank you, Ginevra. Thank you for inviting me. It's a pleasure to be here. And as I was listening to Jorge and to Professor Duvic, I was thinking that this conference is really very timely, not only because of the what Professor Duvic just said about this clearly entanglement almost between development, health, and an environmental issue, but also chronologically, because you are positioned between COP26 and its rather underwhelming outcome, the special session of the Health Assembly that will start in 10 days to discuss a possible new pandemic treaty where environmental issues will figure prominently, in particular the protection from zoonotic risks, and the COP15 of the Convention on Biological Diversity that is already split between, I think a part has just occurred and another part will take place in 2022, and health may also figure in that agenda. So clearly these show also that there's been a process of maturity, of realization, of awareness about the nexus between these agendas. And it's not always been the case, however, because if you look historically, I think, at least as a non-expert, that's my impression, that environmental issues and public health issues, to a certain extent, moved for a long period of time on parallel tracks with occasional points of contact, but without the attempt at an academic level and policy-making level to really establish and study the interaction, the nexuses, and so on. So if you look, for example, at the 1972 Stockholm Convention, so the birth of the environmental movement, it didn't even mention health, I believe. A number of the older environmental conventions subsume human health into the concept of environment as part of the object and purpose of the convention, of the object of protection of the convention. So human health somehow is part of the landscape, even though obviously, if we adopt a more anthropocentric approach, these agendas are eventually for the protection of humanity and human health being a fundamental value. So even though empirically, obviously, environmental problems have a heavy social, economic, and health impact on whole population, Professor Duvic mentioned what's happening in New Delhi with lockdowns due to air pollution, which is a daily problem in many Chinese cities. We see a bit this strange disconnect. So things I think have developed, have come a long way from then. From the legal perspective, for example, I used to work in WHO, as you recall, and WHO and the UN Economic Commission for Europe co-sponsored this protocol on water and health in 1999 that takes a very integrated approach between water management, protection of health, and also from a human rights perspective. And actually, Professor Viñuales is a chair of the compliance committee in that protocol, where the Minamata Convention on Mercury, that has a distinct article on the protection of health, the Convention on Biological Diversity. Since, I believe, 2016, there has been a clear position of human health on its agenda, and there is also an attempt to adapt the regime of the CBD and the Nagoya Protocol to the peculiar needs of sharing human pathogens for public health purposes. The antimicrobial resistance agenda, it clearly has a strong environmental component as part of its fabric. So I think things have moved, and have moved towards an awareness of this mutual reliance and the fact that these two agendas should really talk to each other. WHO has been, if you want, the iconic focus of international public health policy making has been kind of slow on the start, including in factoring the effect of climate change in its agenda. And I think, as Professor Duvic recalled, the fact that the health is mentioned only in the preamble of the Paris Agreement, it is a testament to that difficulty in positioning health in the climate health agenda. But so here we are, and I think the latest manifestation of this process of maturity is COVID-19, that very probably had a zoonotic origin. And so, as I just said, a good part of the discourse leading up to the next Health Assembly and the intergovernmental processes that will start from there have One Health with all its complexity and the need to clearly feel the blind spot in international law on the protection from zoonotic spillover, a part of the health agenda. So there's clearly a process of maturity. So this panel is definitely very timely, and this whole conference is very timely. So I spoke too much. Let me introduce first speaker, which is Alex Phelan. You sort of gave her current position, but let me say a couple of words. She's assistant professor in the Department of Microbiology and Immunology. I hope I'm not getting it wrong. Otherwise, Alex, please correct it. And she also had an appointment as adjunct professor of law at Georgetown University Law Center. She has consulted extensively with WHO, the World Bank, the Gavi Partnership. She's a prolific author on many, many aspects of international health law. And so I think she's the best place to open this panel. Alex, you have the floor.
Thank you very much, Gianluca, for that very kind introduction. That was absolutely spot on in terms of my affiliations, and thank you to the organizers for inviting me today. Let me get this screen happening. So the situation that Gianluca outlined ties very nicely, including linguistically, into the topic of what I will be speaking about today. And I refer to the entanglement of international health law and international environmental law. And I'm using that as a metaphorical entanglement between the two technical areas of health and the environment, as well as a sort of legal theory entanglement between the two. So let's get into it. The main lens that I'm examining this through today is at the pandemic interface. So looking at this, how this entanglement operates through, technically when it comes to pandemics, legally when it comes to pandemics. And then what does that tell us about the evolving legal theory and jurisprudential theory of how we look to multilateralism in dealing with these channels? Gianluca mentioned these parallel tracks historically between health and the environment, and that has often been described as fragmentation as part of one of the broader phenomena of international law, of fragmentation into areas of expertise. And whilst we've certainly seen that crossing over, are we getting to a point of actual entanglement in a positive sense and a plural approach? So what does legal pluralism and looking at legal pluralism teach us about what a pandemic treaty may address? And this works very nicely with how Gianluca set this up, because I'm going to be a little bit what would be the right word? I'm going to push on a few assumptions that we have when we talk about health and environmental intersections, because there is a considerable amount of nuance and complexity, and the actors in the room make a significant difference to the different perspectives that are being highlighted, both in the health forums as well as the environmental forums. And when we come to that intersection and that nexus, we really need to have that nuance. So let's start with technical entanglements. I'm sure you're all familiar with the One Health approach that has been touched upon, but I want to frame this within what One Health approach means from a legal angle. So we know that One Health is this multi-sectoral and multi-institutional cooperation and partnership across human, animal, and ecosystem or environmental interfaces. And it's at these interfaces that from a pandemic lens, we talk about the potential risk of zoonotic spillover or those environmental exposures for human health. Now, in this piece that I'm citing here, Professor Larry Gostin and I argued that without strong governance, these interfaces risk detaching, in way of fragmenting, leaving gaps in capacities to prevent, detect, and respond to emerging and persisting public health threats. So how do we interlink and attach those interfaces? Well, we argue that one crucial component of that governance, that law, including international law, can act as a fixture between those interfaces. So when we start to think about the zoonotic drivers and the anthropogenic drivers of outbreaks, and this is areas I'm sure many people are familiar with, but we know that deforestation and land use change is perhaps the most significant driver of that intersection at the animal-human interface and environmental interfaces, and the potential loss of biodiversity, as well as pressures for zoonotic spillover. Climate change is increasingly getting recognition as the impact of climate change on pathogen evolution in terms of as an evolutionary pressure, as well as the shifting zones and habitats of vectors and potential reservoirs. Typically in the northern hemisphere going north and in the southern hemisphere going south, moving away from the equator as rainfall and temperature changes. There has been considerable attention made on the role of wildlife trade and wet markets as a location, both at the actual hunting and capture, but also at the market side of potential spillover. But also we need to think about the other areas where commercial human activities intersect with animals. We've got, for example, the significant camel trade in parts of the Middle East and MERS. When we look at trying to regulate the wildlife trade, the same sort of approaches may not apply to particularly highly profitable or culturally important animal-human interactions. So we need to think about how law can deal with those risks. And critically, often forgotten in this discussion, is the role of factory farming in particular. So high concentration, high animal density with human exposure. We look at the recent human cases of H5N8, an avian flu that we've had cases in Russia and in China. In Russia, they were all amongst poultry farm workers. And so it's really important to not forget when we talk about zoonotic spillover risk, where we're actually talking about, it's much, much broader. So the anthropogenic drivers of outbreaks is one thing, and we can target laws to address those anthropogenic drivers of outbreaks. And it's important to note that these entanglements are also, they're not unilateral. We often think about this as environmental destruction and its impact on health, but we also have health and its impact on environmental destruction. So for example, there are some really fascinating case studies out of Indonesia where the building of medical clinics was associated with decreased deforestation because of the economic pressure of healthcare was reduced, that shifted the requirement to rely on high profit activities like deforestation. So we need to remember that these are bilaterally linked in many respects. So we can look at using law to target anthropogenic drivers of outbreaks. But I think it's really critical that we don't forget that there's a difference between the drivers of outbreaks and the anthrosystemic drivers of pandemics. These are very different things. The anthrosystemic drivers of pandemics are universal health coverage. Do we have access to primary health care? This is one of the health centers in Kerala, where a Nipah outbreak was pretty rapidly detected at a center that had not been detected in the Nipah virus had not been detected in bats previous to this. This is a critical part of whether an outbreak becomes an epidemic, whether an epidemic becomes a pandemic. Another anthrosystemic driver is racism. We've seen that especially in the United States because it not only impacts access to healthcare, but it has economic flow-on effects in terms of access to sick leave, casualisation of the workforce, essential workforce, as well as accessing healthcare system, whether it's culturally acceptable. If we're thinking about it at the global scale, you cannot get more past an anthrosystemic driver of pandemics than the inequitable access to vaccines and the distribution of vaccines. And we'll see how that may play in terms of the emergence of variants with potential immune escape. And then, of course, fundamentally, as this pandemic has shown, is it's less about whether you have technical capacity in your country. It's more about leadership. It's about governance. It's about evidence-based and decisive leadership. These are what make pandemics. And so I think, one way I like to sort of come back to is there's a piece that we go into a lot more detail on all of these if you're interested. I like to come back to a metaphor that you may know the journalist Ed Young at The Atlantic. He and I have discussed this issue over the last 2 years, many, or even longer, many times. And he was finally able to capture it in a metaphor that I had been struggling to find. And to quote him in a piece from last year, every epidemic is different as new pathogens with unique characteristics emerge from different regions. But those pathogens eventually test the same health systems and expose the same historical inequities. Think of epidemics as a million rivers that must all flow through the same lake. The US has been trying to dam the rivers. It has to focus on the lake. And so I encourage us, when we think about these technical entanglements, we need to think more broadly than just that zoonotic spillover. We need to think about what makes an epidemic, what makes a pandemic as we go forward. So let's have a look at how these entanglements then start to be reflected in legal entanglements. And because we're talking pandemics, I'm going to take the example of surveillance and detection of an emerging infectious disease outbreak. And Gianluca touched on some of these points here. So this is really useful to now sort of walk through. So under international law, countries have obligations to notify the WHO of a potential public health emergency of international concern. There's a whole process for assessing that risk. And as part of that obligation, there is an obligation to share data. The piece of law that I'm of course talking about is the international health regulations. That data is defined as, epidemiological data, clinical data, and case data. And that is critical for responding, but it's not everything that we need in terms of making a risk assessment and then being able to inform the international community about response. And that's when we start to broaden our expansion of what is the sort of information or content that states should share under international law at the beginning of a potential pandemic. So there's, it's quite clear data is covered under Article 6 and 7 of IHR. There's a consensus there. Some countries have interpreted that to, by default, include the sharing of genetic sequences of pathogens. That's not a consensus opinion at all. And it's certainly not one that we could say is normatively at a significant level, but there are some countries that believe that data automatically includes sequences in their practices. We talk then about samples, so the physical samples. Increasingly, the sequences are more critical in terms of risk assessment, development of vaccines, therapeutics, diagnostics, but samples still play, the physical pathogen samples still play a critical role in identifying a potential pathogen and then also conducting risk assessments, testing diagnostics, developing vaccines. The Nagoya Protocol, which Gianluca touched upon, is a legally binding treaty that expressly covers the utilization of genetic resources. And this treaty came into force to really address colonial and neo-colonial exploitation of resources in LMICs, in particular by high-income countries, and that includes through the scientific endeavour. The Nagoya Protocol expressly applies to physical genetic resources. There is this move at the moment, and there was mention of the meeting of parties that happened just the other week, and will continue in February, where they will be exploring whether the Nagoya Protocol should be expanded to include sequences. Now, part of the rationale for that is the goal of Nagoya is to balance access to genetic resources with the equitable sharing of benefits that arise from their use. This is an access and benefit sharing regime. The challenge, though, is if you no longer need that physical sample, if you can use a sequence to get what you need to produce a vaccine, to do your risk assessment, that balance is now being undercut. And so there's, understandably a push from countries that rely on the Nagoya Protocol for global equitable balance to consider the inclusion of sequences here. That obviously has a lot of implications for global public health. And this is an example of the entanglement where, rather than looking at this as a fragmentation and a conflict, this is a potential location for plural interpretations, such as using certain exceptions for public health emergencies, using a carve-out for the recognition of specialised international instruments. And in fact, we do have one specialised international instrument, or at least it hasn't been officially recognised as such, but by the MOP, but it has under a number of domestic laws, including the European Union's implementing legislation of Nagoya, that the PIP framework applies to pandemic influenza. So we have an access and benefit sharing regime that exists to address pandemic influenza. It does have the inclusion of genetic sequence data as an intended inclusion, but that hasn't been fleshed out yet. So you can start to see we have these entanglements, but also these gaps. And so the question is, do we revise the IHR and expand our definitions there and do it in such a way that is consistent with the objectives of the Nagoya Protocol? Or do we adopt novel international law? And the reality is it's probably going to be a combination of the two based on the working group's efforts so far. The big call is obviously for a framework convention on pandemics, and potentially access and benefit sharing could be addressed under that framework convention, but also talk of a separate access and benefit sharing instrument, taking the lessons from the PIP framework and creating a specialised international instrument consistent with the Nagoya Protocol. And this is a way the reason I like this as an example, because it really does start to show us the legal entanglements between international health and international environment. And I think there have been a number of scholars that approach this as a conflict that is resolvable through textual interpretations. I think that this is really an opportunity to embrace the potential for pluralism and also the elevating of global South voices in international law, rather than continuing to displace attempts to address historical and current resource extraction. There are plenty of other areas where the pluralism starts to come into effect, like when countries are implementing their domestic laws for these agreements. And then, we could look at, say, zoonotic disease. For example, in a piece published today in Global Change Biology, routine One Health surveillance data, so not human surveillance, this is all human surveillance, mapped to climate data shows us that the risk of human plague cases in the Western United States has been steadily increasing, and despite that paper not having a forecast in it, likely to continue to increase. And that is an example of where the One Health surveillance is informing humans. So the question is where are our legal entanglements for the zoonotic surveillance in this whole process? Obviously, human rights is another example. The UNFCCC, CITES, the new treaty for an area for marine biodiversity, which is also looking at access and benefit sharing regime. These are where we start to see how these entanglements come together, and we start to actually see a coherence in this pluralism rather than an incoherence in multiplicity. So where does that take us? I think this, as I said, this takes us beyond fragmentation as an endpoint. I think that there are real opportunities here. I think we need to move beyond heavily textual and positivist approaches, which I think really constrain us and use typically highly Anglo-centric legal system interpretations of international law. And I think this is an opportunity to think about what international law and multilateralism means beyond that. A lot of the critiques of these regimes blur the initial sharing for public health response and then the ongoing sharing, in which you could potentially have a more sustained benefit sharing model. And I think we can start to delineate that in the sophisticated access and benefit sharing regime. I think there is often, particularly for high-income countries, an overweighting of how open science currently is. The reality is there are plenty of zoonotic diseases upon which scientists have sat on, because publication or perish is still the name of the game for many scientific careers in high-income countries. And if we're going to be talking about zoonotic risk, we need to be thinking about what are the obligations of sharing in that realm. I also think there has been an under-recognition of the moral catastrophe of global vaccine inequity and what that will mean also for multilateralism going forward. There is no moral high ground when it's quite clear that benefits will not be shared, that there is both an inter and intra-country inequity that multilateralism has a potential to address. I think this also is an opportunity for thinking about how law has the potential to entrench neocolonialism, particularly if we are taking these, interpretive approaches that fail to recognise the purpose of laws like the Nagoya Protocol. And so our path forward, you know, I've just popped a few pieces of literature in here that I think really start to reflect some of my thinking here and where I think the jurisprudence can potentially be evolving. And, you know, the first is regime interaction and moving beyond fragmentation. Margaret Young's work, she's a number of pieces that are really exceptional on this, looking mainly at the trade regime. Anne Peters, who's this piece, her 2017 piece, I will probably cite forever, is a beautifully argued piece about the movement towards legal pluralism of beyond fragmentation. And as Jean-Luc knows, it was part of my dissertation back in 2019. But where I'm really being informed right now is this idea of entanglement and pluralism, and how we can take lessons from entangled legal systems that have existed essentially throughout history, with perhaps the exception of the 20th century. And Kirsch's new book that was released this year is really fabulous on that, if this is of interest. So what does this mean for pandemic treaty? Perfect, I'm at 18 minutes, so this is tied up nicely. I think firstly, the lessons from climate, we really should take clear heed of. There has been a lot of discussion about how the Paris Agreement is a great example of the pandemic treaty. I disagree, as someone who's worked in climate law and health law, is I think the Paris Agreement actually tells us a lot what we shouldn't be doing. The risk of non-binding, the risk of vague obligations, the risk of high-level political statements that aren't necessarily backed by the competing obligations, the allusion to human rights or to health without any substantive consideration of what that actually requires. And we look at how COP26 evolved, and we can start to see the implications of that sort of lawmaking. As part of a background paper for the independent panel on pandemic preparedness and response, myself and another lawyer prepared a piece looking at the comparisons between the climate regime and health that you can find on the IPPR website. And I think it does show us that there are some good lessons in terms of like framework conventions and framework approaches, and the ability to keep that political momentum and capture that high level political commitment without bottling it, which I could potentially Paris has bottled that a little bit. So how can we take that forward? There really is a significant complexity and nuance of this subject matter. It's why I took the time to go in at the beginning, the drivers of outbreaks versus pandemics. And it goes across the realm of topics that have been raised as potential discussion points for the treaty. I think it's really important to think who is in the room, who is representing different perspectives and different views. And part of that means that we must have an equitable and participatory process. Yep. Fundamental to all of this, and the lessons that we should definitely take from where we are now from the IHR, is we have to build norms. We have to take the lessons of the COP26 and having COPs, the COP mock for CBD, and actually build in that norm process into whatever we have as a pandemic treaty. And that way we can start to ensure cohesion as international law and multilateralism does develop. Thank you for letting me take you on that 20-minute tour de force of a lot of different topics, but I look forward to discussing more in the Q&A. So.
Thank you, Alex. A tour de force indeed, but you touched many interesting points. I like in particular your point on we always think of the environmental impact on health, but it can be vice versa. That's a point that I think gets easily lost, and I think it has to be considered more seriously. And also the moral dimension. So morality seems something alien to legal scholarship, but I think there's something very strong in the moral catastrophe, as the Director General Tedros defined what's happening right now. That has to have policy and eventually normative implications. Okay, we'd like now to give the floor to Dr. Tlaleng Mofokeng, that I understand will have to leave soon. Dr. Mofokeng is the Special Rapporteur of the Human Rights Council on the right of everyone to the enjoyment of the highest standard of physical and mental health, so the right to health in brief. And she's been elected by the Human Rights Council in 2020. She's a medical doctor by training, but in particular, long-term and strong advocate, both in South Africa and internationally, for universal health access, HIV care, family planning. She has quite a number of positions, member of the board of Safe Abortion Action Fund, of the Seoul City Institute Board, and she's been commissioner of the Commission for Gender Equality in South Africa, and numerous other positions in the government. So over to you, Dr. Mofokeng.
Thank you so much for bearing with me there. I am just quite privileged to be able to join you this evening to share my insights on today's topic. And I will be looking at environmental health as an integral element to the right to health, and particularly to the restoration of dignity. And for me, this framing around dignity is very important for my tenure overall. And today I hope to just share a little bit of those insights with you. And just to also say that in the coming year to the Human Rights Council, I'll be preparing a report that's focused on violence and its impact on the right to health. And we know that the right to health has defined by the Committee on Economic, Social and Cultural Rights an inclusive right that extends not only to timely and appropriate health care, but also to the underlying determinants of health, such as access to safe and potable water and adequate sanitation, an adequate supply of safe food, nutrition and housing, healthy occupational and environmental conditions, and access to health-related education and information, including on sexual and reproductive health. And so the framing of my next report takes into account and seeks to put focus and a spotlight on some of the abuses and violations and violence that experienced by people, especially around underlying determinants of health. And so today is particularly important for me, but also asking you colleagues to be on the lookout for that call for contributions, where you can actually share some of your insights around issues of environment and climate and how they concern all of us. And I think a regional perspective would be really appreciated. Now, a further important aspect is the participation of the population in all health-related decision-making at the community, national and international levels. And furthermore, the right to health is closely related to and dependent upon the realization of other human rights, including the rights to life, non-discrimination, equality, prohibition against torture, privacy, access to information, and the freedoms of association, assembly, and movement. And we can see these key human rights principles, how they can be applied to the issues that are concerning us today. And all of these and other rights, not limited to the ones I've spoken about, and freedoms address very integral components of the right to health. Now, particularly the Committee on Economic, Social and Cultural Rights have recognized that the social determinants of health affect the realization to sexual and reproductive health rights, both between and within countries. Patterns related to sexual and reproductive health rights typically reflect social inequalities and power distributions based on income, gender, citizenship status, age, disability status, systemic discrimination and other factors, as well as health discrimination. To eliminate the links between sexual and reproductive health and the environment, we have to turn our attention to the brutal history of human rights violations and abuses committed as far as slavery, colonialism, apartheid, and to see how these legacies live on today. And I'm speaking as someone who still lives and works in a country that has a very recent history of apartheid, and I live in South Africa. And when adopting the mandate on the right to health, I was clear in my focus on anti-discrimination, anti-coloniality, because it has permeated formal, or at least outlived formal colonialism, but also intersectionality in pursuit of substantive equality. This is necessary for the ultimate goal of the restoration of dignity of all people. And of note, climate change and environmental justice, I have observed some of these interactions with health and human rights that deserve further interrogation. Now, the historical impacts of slavery and colonialism on sexual and reproductive health rights are multifaceted. Broadly, colonial regimes have seen reproduction primarily in very instrumentalist terms, promoting it when it was deemed valuable for economic or political objectives, and discouraging it when it was deemed undesirable. Maternal health programs created by European colonial powers in Africa and the Caribbean in the early 20th century, for example, were driven largely by a perceived shortage of labor needed to work on plantations and in export industries. And colonial and post-colonial regimes, as well as many international organizations, then shifted to discouraging reproduction and promoting family planning in the mid-20th century, when smaller families were deemed more conducive to national economic development and global security. And so the connections among fertility, family size, and the broader socioeconomic development continued to be debated, strengthened by the resurgence of the rhetoric of population control in the context of climate change. And in the era of the climate crisis, it must be noted that these resurgent discourses make their way into social and policy discussions and attribute wrongfully environmental destruction to the reproduction of poor people, mostly in former colonized countries and the so-called global south or developing contexts. And this approach places the burden of climate change on those who are least responsible for producing it. And 13 deaths occur every minute around the world as a result of air pollution caused primarily by fossil fuels, which drive climate change. And the people who pay this price are not the people who are causing this particular crisis. People in developing nations, as well as indigenous people and communities who live sustainably and have cultural practices that are deeply intertwined with nature, are seeing not only a destruction of the environment, but also their culture and subsequently their spirituality and their connection to nature and their human rights. And these costs of climate change and the crisis we are currently experiencing reverberate beyond the limit of industries and economies. Now, racism and its influence in spatial planning of towns and cities means that the space that many people of African descent and their communities and indigenous communities live in very high polluted areas of air and water pollution due to industry activity, spaces that are high density that lead to poor ventilation, more chronic illnesses such as hypertension, diabetes, and asthma, and all of which have been known and reported to increase severity and mortality to the COVID-19 virus. And so the intersection of environmental health, racism, the historic nature of how particular communities are marginalized becomes very obvious when you then talk about COVID-19. And this is a form of ecological violence that is suffered by the most vulnerable in society, again, those who are in a position of power where they are unable to get recourse. And so when we talk about saving the environment, are we thinking about the lives of such people? Or are we just merely speaking about what suits industry and services profits? And so the nexus of environment and health are lives that are often overlooked. We cannot assess the environmental crisis without acknowledging the ways in which legacies of colonization has created industries that have no regard for the well-being of living beings, seen only for their capacity for labor and profit, and the exploitation and continued extraction seen at the forefront of this crisis has its origins in colonial conquests. And I implore us to see how these legacies live on today. And so reversing climate change must go hand in hand with developing an anti-colonial, suitable industries that serve everyone without the need for exploitation. And there may be those who say this is perhaps not possible, but alongside these industries have been centuries-long examples of sustainable indigenous practices to model industries after. And I just want to say that I want to quote Wangari Maathai, who's a feminist environmentalist who won numerous awards globally and recognized internationally for her work, when she says, "We are called to assist the earth to heal her wounds, and in the process heal our wound. Indeed, to embrace the whole creation in all its diversity, beauty, and wonder. This will happen if we see the need to revive our sense of belonging to a larger family of life with which we have shared our evolutionary process." And this statement reminds us, as I have, that a holistic approach to the environment aims to protect life and find ways to coexist, not sacrificing some lives over others. And therefore, there must be meaningful participation by those mostly affected at all decision-making levels of local, national, and regional and international spaces. And civil society participation is key. It must be encouraged and the participation of civil society must be protected and supported by transparency in order to rebuild trust as a global community. And in closing, I just want to say that intersectional and human rights-based frameworks must guide all of our efforts, and our call for accountability mechanisms in pursuit of substantive equality necessary for the restoration of dignity of all people. Thank you very much.
Thank you very much. That was another tour de force. Alex entangled environment and health from a legal perspective. You brought the human rights perspective, which is something that should never be underestimated. In particular, as you correctly said, that environmental impact is never equally distributed. Most of the disasters are man-made, long-term consequences are equally man-made. COVID has not been the big equalizer that at the beginning we were thinking it would be. It has had and it continues to have a deeply unequal impact that shows and multiplies existing systemic inequalities, inequities. So very, very timely and very cogent presentation. Ginevra, give you back the floor. Many thanks for letting me moderate this panel.
Thank you, Gianluca. Thank you also to all the speakers in the first panel. Really, I think all the core aspects of the nexus between health and environment were really touched upon, the discussion of the technical legal entanglements, but also issues of inequality, and also how to take lessons from the past and from what we have now. It's a pleasure now to build on the outcome of this first panel and open the second panel of our conference, specifically devoted to systemic implications of environmental crimes. Now, environmental crimes encompass a broad range of illegal activities, with the highest profile area of illegal natural resource trade being the trafficking of wildlife. And the uneven distribution of natural resources and illicit trading can considerably affect human health, the ecosystem, biodiversity, as well as sustainable development, as it was also mentioned in the introduction. So this raised question on the role, scope, and effectiveness of international criminal and transnational law to constrain such activities. And some scholars are focused on illegal wildlife trade activity and the prevention. Others on, more recently, also on providing a legal definition of the crime of ecocide. And others have instead tried to better understand the links between illegal wildlife trade and its negative impacts on biodiversity and society. So today we'll try to discuss the implications of environmental crimes by looking at different lenses and different angles. I would like to start with our first speaker. I'm very pleased and honored to introduce Mr. John Scanlon. As mentioned, since 2020, he is acting CEO of the Elephant Protection Initiative Foundation, and he assumed this position permanently in November 2020. He also assumed the role of chair of the Global Alliance to End Wildlife Crime, and in July 2020 was appointed as chair of the UK government's Illegal Wildlife Trade Challenge Fund. And he was also Secretary General of CITES from 2010 to 2018. And before joining CITES, he was Principal Advisor on Policy and Program at UNEP, and also Director of the Environmental Law Center and Head of the Environmental Law Program with IUCN. And he was also Special Envoy for African Parks from 2018 to 2020. So without further ado, I'm now going to give the floor to Mr. John Scanlon, whose presentation is titled Ending Wildlife Crime to Protect Animals, Human Health and the Planet. So Mr. Scanlon, you'll have the floor.
Great, thanks Ginevra for that very warm welcome. And thanks for the invitation to you and all the co-conveners for inviting me to join you this evening. It is this evening here, it's getting a little bit dark. Warm welcome to everyone who's online joining us today. You know, I think if we look back to this time last year, we thought by now we'd be coming out of this COVID-19 pandemic. Sadly, that's not the case. I was just in Vienna last week and I see that Austria has today announced another lockdown. But governments are continuing to work to vaccinate and also to find out what the origins of this pandemic were. At some stage, we're going to get through it, but when we do, it won't be over. In fact, far from it. Now, I think you're probably familiar with the recent World Health Organization report, which says that the most likely explanation of COVID-19 is that the virus jumped from an animal, such as a bat, to humans, possibly via another animal. And I was just reading some media today, actually, which was talking about where case zero actually came from. And there's some new reporting suggesting that it actually did come from the Wuhan market, as was originally suspected. But some interesting new reports on that today. Anyway, I think it's probably still too early to draw any final conclusions about the origins of COVID-19, but we are increasingly aware of the links between wild animals and previous pandemics, as well as the conditions that make the spillover of viruses from animals to humans more likely. And we've heard about some of that today. Health and wildlife experts have warned us for some time now of the public health risk associated with people mixing with wild animals, including through habitat destruction, illegal or poorly regulated wildlife trade, and through the sale of wildlife at markets, especially those that bring together wild, captively bred and domesticated animals. It's always important to say that we need to be mindful of the fact that when left alone, wild animals don't pose any risk to human health. The risk comes from how we as people interact with wildlife, and that's something we can manage. Now, it's not just the health risk we need to be concerned about, as you just alluded to. In addition to these risks, the UN IPBES, you'll all be familiar with the IPBES, predicts that due to our own actions, 1 million species will go extinct over the coming decades. For many reasons, overexploitation, including for illegal trade, loss of habitat, and many others. But it makes an important comment there. It says, unless we change course. Now, as we've all been saying today and for some time now, climate change is at the top of the international agenda. And one response to help mitigate climate change, as you know, is nature-based climate solutions. And this got a lot of attention in Glasgow, which was good to see. They can offer about 1/3 of the carbon dioxide mitigation needed to 2030. But habitat loss, overexploitation of wildlife, including for illegal trade, degrades these ecosystems and their ability to sequester carbon. And therefore it serves to undermine efforts to advance nature-based climate solutions. Put very generally, this pandemic has reminded us in a devastating way of how interconnected everything is between economies, the environment, human and wildlife health and welfare. And it's quite obvious, I think, to all of us now that we need to recalibrate our relationship with nature, and to do so for many compelling reasons. Protect biodiversity, combat climate change, prevent future pandemics are the three that we're most concerned about today. But that's not going to happen all by itself. It's going to require profound changes in how we regulate the taking, trade and consumption of wildlife, how we combat wildlife crime, and how we manage and finance the protection of wildlife at its source. Now, in the time available, I'm going to briefly touch upon two issues, wildlife trade and wildlife crime. And as you mentioned in your opening remarks, I'm fortunate to chair the Global Initiative to End Wildlife Crime. This is a diverse group of individuals and organizations coming from across every continent who have joined forces to promote certain changes to our international laws. Our initiative thinks that the current international regime for regulating wildlife trade and combating wildlife crime is inadequate in setting the framework for regulating the trade, markets and consumption that pose a risk to public health, as well as for ending wildlife crime. And we are promoting changes to the existing international legal framework that will enshrine into law agreements between states on how they will work together to help prevent future pandemics and end wildlife crime, and in a manner that delivers multiple local and global benefits. Now, I'll briefly share with you our concerns about existing international wildlife trade and wildlife crime laws and outline for you our suggested reforms. Our starting point is that these are challenging, global, interconnected issues. Viruses can spill over in any country, and wildlife crime is a scourge affecting every continent. And of course, countries can always act alone, but effectively tackling these risks will require a collective response. And as such, it's preferable to agree upon and to follow a common set of rules to address the risk of pandemics emerging from wildlife trade and wildlife crime from anywhere, both now and into the future. Now, firstly on wildlife trade, and this is dealing with both regulated and unregulated trade, the global agreement that exists to regulate international trade in wildlife is CITES. It's known by its acronym, and you've just made reference to it. CITES takes decisions based solely upon biological and trade criteria. It looks to see if any trade will affect the survival of the species of animal or plant that is being traded. Does not pay any attention to the risk that such trade could pose to human or animal health, nor does it address wildlife markets. Now, in our view, this needs to change. Regulating wildlife trade needs to be based on a One Health approach, which we've heard a lot about today, where biological, human health and animal health criteria are all taken into consideration. And we're already seeing some states start to impose further restrictions on trade and markets, for example, in China, Gabon, Italy and Vietnam, which is good to see. And the WTO, OIE and UNEP have called on national authorities to suspend the trade in some live caught wild animals for various purposes and to close sections of food markets as an emergency response. But to be successful, we need to encourage a collective effort and to recognise that human memories are short, as is clear from the responses to previous pandemics. To succeed, we must hardwire a One Health approach into the agreed international legal framework, which will in turn be reflected in national laws. And there are several options to achieve this objective. I'll just deal with two today. States could adopt amendments to CITES that build human and animal health criteria into its decision-making processes and to extend its reach to wildlife markets. Now, we know how to do this. In fact, we've drafted up a set of amendments that could be made to CITES, and the process is quite clear. The reality is, however, that CITES parties have been traditionally wary of extending its mandate. They like to keep it quite narrow in its focus, and they may elect not to take up this opportunity. But there is another viable option, and which comes from the initiative we've talked about today of the global health community. And that is to ensure that the scope of the proposed International Pandemics Treaty includes legally binding commitments on taking measures to prevent the spillover of viruses and other pathogens from wild animals to people, including through wildlife trade and markets. This would serve to institutionalise a One Health approach, both now and into the future. And we've released a short briefing paper on this option, which we've shared with the WHO and many others, as it assesses the possible benefits of such a treaty. And as you all know, the World Health Assembly will meet later this month to consider its response, not just to what we said, but consider its response to exploring the potential benefits of such a treaty. Now, moving on to wildlife crime. In addition to posing a threat to human and animal health, wildlife crimes are driving many species towards extinction. They degrade entire ecosystems and their ability to sequester carbon. They deprive governments of up to $12 billion in revenue a year. They exacerbate corruption, insecurity, and poverty, and are associated with a range of other crimes, including money laundering. If we look to all species being illicitly trafficked, not just the limited number of species regulated under CITES, which is 38,000 of 8 million species, and if we include the impacts of these crimes on ecosystems, then the World Bank estimates their value at a staggering $1 to $2 trillion per year. In addition to this, as more restrictions are imposed on certain wildlife trade and markets, it's going to require an enhanced collaborative enforcement effort to ensure such activities do not just move underground. Yet, notwithstanding the known destructive and high-risk nature of these crimes to both people and wildlife, there is no global agreement on tackling wildlife crime, as there is, for example, on human trafficking. And in the absence of any alternative, we have to date relied heavily on CITES, which is a 50-year-old trade-related convention. It's not a crime-related convention, nor is it a natural forum for police or other enforcement officials. But in the absence of anything else, we did make best use of it. But with enhanced global connectivity, the ability of organised crime to operate across international borders, and the trafficking of wildlife at an industrial scale, is going to require enhanced global cooperation and national responses to tackling these crimes. It's time to embed combating and preventing these crimes into the international criminal law framework. And we've released a first working draft of the possible form and content of a new global agreement on wildlife crime to help advance this discussion. The draft has many suggested elements, including setting out the conduct to be criminalised, committing states to make it a criminal offence to import any wildlife that is acquired in contravention of the laws of the source country. And this would represent an expression of comity between nations or a mutual respect for one another's laws. And it also includes issues such as the exchange of critically important information, including on forensics. It would apply to any species of wild fauna and flora, including fish and timber species, that is protected under any international or, importantly, any national law. So it would extend well beyond CITES listed species and include the millions of species that are not listed by CITES, but may be illegally harvested and traded internationally, as is frequently the case with timber and fish trafficking. Now, I'm delighted to inform you that in May of this year, the presidents of Gabon and Costa Rica, these are two very biodiverse rich countries, as you know, jointly called for a new global agreement on wildlife crime, taking the form of a protocol under the UN Convention Against Transnational Organised Crime, and they reached out to other states to join them in this endeavour. And in September, this call was supported by the president of Angola, and I'm just back from Vienna, where I was at the UN Crime Commission meeting and addressed the Commission on this issue and spoke with a number of members of the Commission. Now, we heard some comments earlier made about Glasgow and Kunming. Kunming, obviously, where the Convention on Biological Diversity will convene to adopt the post-2020 Global Biodiversity Framework. That framework has a number of targets. As yet, there's no reference to crime within these targets, including wildlife trafficking, which is something we believe needs correcting, nor is there any reference to taking a One Health approach. There is reference to human health in one target, but not to animal health. So to sum up, the world is still feeling the full brunt of a pandemic, which most likely had its origins in a wild animal. We're advised that there are hundreds of thousands of new viruses that could spill over from wildlife to humans. We're struggling to combat climate change and staring down the loss of a million species. In our view, given the scale of the risk to people and planet, we have to ratchet up both our national and global responses to these threats. And if we get it right, the local and Indigenous communities living amongst wildlife, legitimate investors, and the governments of source countries, as well as our global biodiversity, climate, health, and security, will all be beneficiaries. Thanks for the invitation to join you.
Thank you very, very much, Mrs. Scanlon, and for your very clear presentation on the interaction between humans and wildlife, and also on the importance of collective response and on considering also one health approach, as was also mentioned before, to really prevent outbreaks and also prevent future crimes, environmental crimes. And also for giving us some insights on possible future developments in this area, the legal level, and also the policy level. So now I'm going to give the floor to Professor Wyatt. She's a professor of criminology specializing in green criminology at Northumbria University. Her expertise centers on wildlife crime and trafficking, non-human animal abuse and welfare, and the intersections of organized crime, corporate crime, and corruption. From May 2018 until May 2020, she has been researching best practice and lessons learned concerning implementation and compliance with the CITES. And she's also worked on various projects for the US National Intelligence Council on timber, the National Consortium for the Study of Terrorism and Responses to Terrorism on Wildlife Trafficking, links to terrorism. And she's also served as an advisor for the Wildlife Crime Technology Challenge and the USAID-funded Targeting Natural Resource Corruption project. Professor Wyatt, today's presentation is titled Environmental Crimes' Role in Planetary Insecurity. And she will also talk about the ways in which the range of environmental crimes threaten human and the planet's security in terms of health, food, and safety. So Professor Wyatt, you have the floor.
Great, thank you. Thanks so much for the invitation today, Ginevra, and for everyone in the audience that's listening. I'm actually going to frame my talk around what are called the 9 planetary boundaries. And these were created by Rockström and colleagues at the Stockholm Resilience Center in 2009. And I think it provides a really interesting framework where you can break down the different kinds of environmental crimes that are actually creating insecurities in very systemic ways, as the topic of the panel is this evening. So first of all, just to quickly basically recap what Mr. Scanlon had talked about earlier around wildlife crime and wildlife trafficking. One of the first planetary boundaries is around biosphere integrity, and here's where we see that wildlife trafficking plays a huge role. And not only in threatening just the exact number of species, so the overall biodiversity that we find on our planet, but also around what Rockström and colleagues talked around in functional diversity. What wildlife crime actually can, in particular instances, target specific types of animals within a population, or specific types of plants within a population. So we see this, for instance, in the context of trophy hunting, where the elephants with the largest tusks are the ones that are targeted, and that has functional diversity implications potentially. So crime plays a role in our biosphere integrity. And of course, that has security implications in terms of human security related to people who are reliant on wildlife for food or medicine or other kinds of livelihoods. The second planetary boundary, of course, is one that I think other colleagues here tonight have covered very well around climate change. What maybe we haven't gone into so much are what are the crimes that are contributing to climate change, and they aren't necessarily crimes. And myself as a green criminologist, which is a kind of critical criminology, where I wouldn't necessarily only limit myself to talk about what is legally defined as crime. I would also want to push the boundaries of maybe what should be criminalized because it's harmful, or what Nicholas Passos has called the lawful but awful, right? So those activities that are incredibly degrading and damaging, but are perfectly allowable but still causing harm. And in the context of climate change, that is, of course, extraction of fossil fuels, burning of fossil fuels, and all of the ramifications that has. And that is going to have huge security implications, increasing security implications. I think we're already starting to see that just these last few days, the massive amounts of flooding in my original home part of the world in the Pacific Northwest. So this time in Canada, but we've seen also wildfires in Washington, Oregon, California, Australia, all of these kinds of climate change related things that are going to have further security implications for people. There's also novel entities as a planetary boundary. And here we're talking about all of those variety of pollution. So we could think of fossil fuels, obviously, and climate change as a form of pollution around carbon and methane. But what are the other kinds of persistent, long-lasting chemicals, toxins, contaminants that humans are putting into the environment? Plastics is a huge one that's come into the real attention of people, I think, over the last years. And that has lots of implications in terms of security of, we're discovering that there's microplastics basically everywhere on the planet, finding them in the Arctic, in deep water trenches. So those sorts of issues, and crime plays a role in this as well, but so does harm. So in terms of crime, and pollution related to novel entities, I think we could make a case around illegal waste dumping, which is a large problem throughout the world. And here, someone had mentioned earlier on the panel, what are the role of corporations and businesses in all of this? So we do know that it's a persistent problem, and it's well documented in the literature of corporations cutting corners by dumping waste in various ways. Even local councils or governments saying that they're going to recycle and then actually dumping that recycling in places. And this is how we're getting other kinds of pollution into our world. And so that's one kind of crime that is also contributing to the insecurities and the limitations being pushed for these planetary boundaries. The fourth planetary boundary you see there is the stratospheric ozone depletion. And we thought we'd made lots of progress on this in the last year. So there's the Montreal Protocol, which had arranged for the phase out of hydrochlorofluorocarbons that are these ozone depleting substances that we've known for decades are damaging the ozone layer, which has lots of implications for human health in terms of without the ozone of the sun becoming damaging in particular parts of the world. And of course, that has not only human implications, but implications for other species as well. And so the Montreal Protocol identified the particular substances that we needed to phase out, and that had been going very well. I think there's probably some good evidence coming, particularly from the Environmental Investigation Agency in the last years, that there's probably some backsliding on this, because they have, through some really robust investigations involving satellite technologies and other ways to monitor activities of corporations, that there are, it looks like, clandestine industries in China and possibly other parts of the world that are again still probably still producing ozone depleting substances, even though we should, as I said, be phasing these out. So here we have crime contributing to that. So those ozone depleting substances are then trafficked behind the scenes, or some laundering going on of saying they're a legal substance when they're not. So that is criminal, but also we have regulatory issues or civil issues that are blended into that. We don't know much actually about the fifth planetary boundary there around the aerosol loading. Aerosols too are another substance that we know have been phased out because we learned decades ago of how harmful they were. But we're not sure, or don't have all necessarily the right information and the right data to be judging on that, where we are in terms of reaching that boundary. And so I don't know if anyone's looking into similarly of laundering or crime related to that particular issue, but that is one of the areas that we need to maintain within certain limitations to maintain the integrity of the planet. Ocean acidification, here too we have crime linking into the boundary on ocean acidification being reached. So our oceans are becoming more and more acidic, which obviously has implications for all of the marine life that's there. That obviously has security knock-ons too for biodiversity loss and all of the human livelihoods that are linked to marine systems. And the acidification can be caused by a number of factors. Pollution is obviously linked into that, be it plastics, but here we're mostly talking about other chemicals that are getting dumped or leaked or just transferring into the ocean. And particularly that has a lot to do with industrial agriculture, which links very closely to that next boundary around biochemical flows, which really break down in particular to be about phosphorus and nitrogen. And both of those are predominantly from the forms of fertilizers, pesticides, rodenticides, insecticides, all of these chemicals that we're using to maintain our agriculture and our crop growing. And those chemicals We use them in tremendous amounts around the world, and that has implications for the ocean acidification because the nitrogen and phosphorus coming into the oceans impact upon the pH of the water, and then also flows on to the next planetary boundary around fresh water use. So you have nitrogen and phosphorus that are impacting on all of the contamination related to our water. And here I think this is where we're really talking much more about environmental harm, if we're being precise with our language rather than environmental crime, because obviously fertilizers and pesticides are legal. There are some that have become illegal, so we might edge into crime there in certain instances if farmers and industry are using certain fertilizers or pesticides that have been outlawed. But for the most part, these substances are all legal, but we're using them to such a degree that they're having a huge impact on our environment and on our biodiversity. And so it is much more of a harm that we're talking about there. Now, I mentioned around freshwater use, so we need to be worried about the pollution of freshwater, also stemming from these various pollutions that I've talked about. And I've just mentioned that we know the issues around freshwater are very present. So I'm based in the UK, and there's frequent stories, particularly in London, around two particular water companies that are known for regularly just dumping human sewage into waterways. And all that's been happening with that are fines. That's really been the only response of law enforcement. And I should say it's a regulator rather than a police force. So in this context, it isn't at most stages a criminal offense, but it is a regulatory violation. So the recourse is fines. Now, when it reaches a certain level, it could become criminal, but it's been documented in the literature, and people who have interviewed many of these regulators, the regulators are quite honest that criminal kinds of punishment for this are the last resort. For the most part, there's a lot of negotiation, trying to get compliance from industry in particular, and then it might move on to fines and repeated fines. And so treating these as crimes is really a last resort. And just another issue around freshwater use, particularly related to the security context, is we see around the world the trend of fresh water actually being privatized. So corporations actually owning the rights to water and then selling it back to people, or diverting its use from going into people's homes to making various products of we've seen that with Nestle and Coca-Cola and other companies around the world. And that has huge security implications for people in marginalized areas, impoverished people who wouldn't be able to afford paying for water. And there's a lot of human rights implications for that, but security issues, obviously, of everyone having access to fresh water. And then the last planetary boundary is around land system change. And this links in closely with biodiversity loss, because what the land system changes that we're seeing are the range of ecosystems being changed over, again, primarily for industrial agriculture. So we tend maybe to think of deforestation as one of the big land system changes. So, you have a forest and all of the trees just chopped down to have some sort of crop, cattle, or whatever agriculture might be going in there. But we shouldn't forget that this is happening to other ecosystems too, which have environmental security implications for ecosystems collapsing or ecosystems being lost. So we see a huge loss of peat bogs, which are really important. So these types of wetlands hold a lot of biodiversity and are really important for carbon storage and biodiversity. But we also see this happening with grasslands and prairies around the world too. So land system change is one to worry about. and obviously has links to environmental crime. So could be illegal logging, but we could also consider under this, I think, a lot of new data coming out about illegal mining. So where we have destruction, or again, often businesses, but maybe some artisanal, so individuals out mining that are, and that could be for a variety of minerals. And the first speaker mentioned around, we're going to have to worry more and more about this as we transition, hopefully, to a cleaner kind of energy because of the mining of lithium and other kinds of minerals that we're going to need for our cleaner kinds of energy. So I think those 9 planetary boundaries are really an interesting frame for talking about environmental crime and those links to insecurities. And that's going to be human security linked to access to food, access to water, and to livelihoods, and then the environmental security in general. But I just want to end on the point that underlying all of this, I would argue, is a form of exploitation that often goes undiscussed, and that's around non-human animal exploitation and abuse that fuels so much of this. So the wildlife crime, the wildlife trafficking, industrial agriculture, where we see huge amounts of exploitation of non-human animals, and that in itself is not often a crime and is not often considered. And so I think that would be something that we need to get onto the agendas, and it didn't come up, as other colleagues have mentioned, at the at COP26, where the non-human was pretty absent from any of those kinds of discussions, even though climate change stems in some part from their abuse in terms of being systemically abused for human food, but then there are also going to be victims of climate change as well. And so I'd like to see the conversation turn more about regeneration and restoration that would involve ending these kinds of exploitations. And that there are some movement in that direction. So the American Bar Association, for instance, has drafted a universal declaration about animal rights. And so there are international kinds of conversations in this space that are trying to make wildlife crime or environmental crime and the systemic implications that it has much more visible. Thank you.
Thank you, Professor Wyatt. If you could, okay, wonderful. Thank you so much for your interesting presentation, also built around the frame of the 9 planetary boundaries, and really also touching upon issues such as climate change and pollution and security implications, as well as also the role of corporations, of industrial agricultural, and also the impact on the environment and biodiversity. And last but not least, also the role of local measures and local enforcement. So now we are moving the focus from criminal law to international criminal law. I'm going over to our last speaker, Professor Derry Robinson, professor at Queen's University, Faculty of Law. His research focuses on international criminal law and justice. And before joining the Faculty of Law, Professor Robinson served as a legal officer at Foreign Affairs Canada from 1997 to 2004. He also joined the International Criminal Court as an advisor to the chief prosecutor from 2004 to 2006, and helping also to shape the first policies and strategies of the new institution. And he was also involved in litigation, providing legal advice, negotiating cooperation agreements with the UN, Interpol, and others, and strengthening external relations. Just last year, his books "Justice in Extreme Cases: Criminal Law Criminal Law Theory Meets International Criminal Law" was published by Cambridge University Press. And in his presentation today, he will discuss the recent draft law on the legal definition of ecocide and the issues in defining and adopting it. So Professor Robinson, you have the floor. Thank you.
Thanks very much. Yeah, I'm going to talk to you about the proposed crime of ecocide. I've been working on this for maybe a year and a half for the Promise Institute on Human Rights, was working on a definition. I've been doing other projects. I think if you're interested in ecocide, I think there's about 3 big questions. One, is it even a good idea? Or is it a bad idea? Number 2, if we do it, should it be in the International Criminal Court or should it be on national laws? And then the third and hardest one is, how do you define this? So starting with the first question of, is this a good idea? I have to first acknowledge there's arguments against criminal law is the answer. First of all, responding to the kind of environmental crises we've heard about here, that's going to require complicated societal reforms. And of course, criminal law is not the tool to achieve that kind of thing. A second argument against is a lot of the environmental harm today, it's actually caused by individual actors, each having a small impact. So you don't have that one big villain to charge. Nonetheless, I'm in favor of a crime of ecocide. The previous speakers have already told us about, given us examples of the ways where we know that humans are destroying our planetary home in a rapid and large scale way. And we're creating threats for the health and the well-being of present generations and future generations of humans and other species. So I think ecocide meets all the hallmarks of international crime. It has impacts that go over state boundaries. National regulation has proven insufficient, and then the harms are devastating. I mean, we heard some examples today about 13 deaths a minute from pollution. That eclipses anything that international criminal law currently does, or losing 1 million species in the coming decades. And we can't rely on national laws because they've proven to be patchy, uneven, unenforced, often corrupted. One of my big hopes for a crime of ecocide is what we would call in criminal law the expressive function of criminal law, which is the idea that we can shape how people think. So currently, as Tanya was just saying, most environmental harm is treated as a regulatory offense. It's much less serious. And the idea is to reframe the most egregious environmental wrongdoing in accordance, to stigmatize it in accordance with its actual gravity. And that also answers one of the sort of criticisms is that people say, why do you have to use this word ecocide? Why do we need this made up word? And the answer is because it's a striking word, and surveys of people show that it's shocking. It captures their attention and imagination. And polls show people think there should be action on ecocide. There's another benefit to a crime of ecocide. Criminal law tends to let's say it underfocuses. Criminal law doesn't pay attention to crimes by the elites and by wealthy. International criminal law is under a lot of criticism right now for overfocusing on crimes in the global south. But whereas with the crime of ecocide, ecocide's a crime that the perpetrator groups are probably largely in the global north, but the impacts are felt in the global south. Addressing ecocide could be kind of a corrective to reduce the structural injustices of the system and give us something more equitable. And I have to underscore, no one suggests that adopting a crime of ecocide is going to solve all the problems. That's not at all the goal. It's just that it might make one small contribution in shaping how people think about, how even businesses and states think about these kinds of acts, and to ask themselves, oh, is this thing I'm contemplating, is it ecocide? So that's the pros and cons. Issue 2, what about the forum? A lot of the energy right now is focusing on amending the ICC statute, which is fine with me. Let's go ahead and use that momentum. I should say, though, that there's 2 ways to get a crime of ecocide. One way is we get it adopted in the ICC statute, and then it percolates into national laws. But we could do it the other way. We could get a critical mass of states all doing it on their own, adopting their legislation, build a wave, maybe get some sort of treaty or declaration, and then get it going in national systems, then later put in the ICC statute. I should say, for trying to put it in the ICC statute, you need to get 2/3 of states to agree. And if you do it, you're giving this crime to one institution that's already pretty overwhelmed with the cases it has. So it might do one ecocide case a decade or something. So that's why more important to me, however it's done, the more important part to me is getting a wave of countries adopting a crime of ecocide. And so that brings me to the hardest part. And by the way, I'm going to go shorter than the time allotted, but the definition, that's the hard part, because for me, I'm 100% convinced, yes, we need this crime of ecocide, but how to define it, that's what stumps me. I was involved in the Rome conference that made the International Criminal Court statute, where we defined the other crimes. And what we did there is we took prohibitions from human rights law and humanitarian law. We took the things that we could all agree on that were the worst of existing prohibitions, and we criminalized them. So when I first started working on ecocide, I said, well, I assumed it would be the same playbook. We'll just do the same thing. But when we turn to the environmental treaties, environmental treaties do not have hard prohibitions in the way that humanitarian law does. They instead tend to announce, here's some principles that states should take into account when you're, considering any kind of a project with environmental impacts. Here's caps and trading regimes. There's exceptions for developing countries so that they can fight poverty. So environmental law is actually all about balancing different factors. Well, that creates a lot of challenges, because where international criminal law has succeeded, it's where we identified and delineated something that all the states could agree, or most of the states could agree, that's terrible. And there was a strong moral consensus. And that gets us acceptance, legitimacy, critical mass, lets us have an impact. But where is our clear prohibition that we can criminalize in environmental law? It's tricky. However ecocide gets defined, I think there's going to be three big ingredients. One, there's going to be some sort of impact threshold. So we talk a lot about widespread, long-term, severe impacts. That's sort of, there's coalescing around that. Two, there's going to be some kind of mental element, because for criminal law, we're going to require some kind of foresight. But the third and hardest part is how are we going to align this crime with environmental principles? That's the exceptionally hard part. In June of this year, an international panel put out a definition, and it talks about, it's about environmental impacts that are widespread, long-term, severe, but it asks, was it unlawful, or did it show wanton disregard for the environment, that kind of thing. A common reaction, a lot of the criticisms of it were, well, why do we even care about whether it's wanton or unlawful? Why can't we just criminalize anything that has a big impact? Which is an understandable first reaction that we all went through. But there is probably a reason why we do need some requirement of wrongfulness. Right now, we've got about 7.8 billion people on the world. They all need food, clothing, shelter. So they have a certain footprint. Each of you listening has a footprint just to stay alive. So if there's some company that's providing food for hundreds of millions of people, you multiply, it's actually going to have some significant environmental impacts, even if they're taking all the measures they can to reduce their impact. And then you might say, well, maybe that just shouldn't be allowed. We could just ban having a big impact. But the problem with that is we would then immediately criminalize, for example, all the food supply chains, and which would cause a lot of suffering. Ironically, it would increase pollution, because now everyone has to go get food for themselves somehow, which would lead to a lot of waste. That's why environmental law is probably right when it looks at factors, as much as it frustrates us sometimes, but it looks at what are the social benefits, what is the harm, what measures are you taking to mitigate or avoid damage, and it also looks at other factors like eradicating poverty in developing countries. It looks at all these factors. And international criminal law is supposed to just criminalize the hardcore of what's already agreed. So I think ecocide probably has to reflect those features of environmental law. And it would still be radical if it did that, because at the moment, there's not much in the way of enforcement. If we could get enforcement, if we could just sort of carve out the worst violations of environmental principles, criminalize just those, the most egregious, there would still be a lot of work for the crime of ecocide to do, because there are a lot of projects going on. They don't have social benefits. They're for the benefit of a wealthy few. There's corruption involved. They're not taking measures to mitigate harm. So it would still catch a lot of activity. And I guess there's a couple ways to do it. I'm not going to try to explain them, but there's a couple ways to do it. So one is we could refer to, was it unlawful in international law? The problem with that is international law doesn't have a lot of clear prohibitions. Another thing we could ask is, was it unlawful in domestic law? That's sort of good because there's more rules there, but then the problem is you have very different standards. A third promising avenue is we talk about, the panel used the word wanton, meaning were you showing wanton disregard for the balancing, that the social benefits are just not proportionate to the harm that you're inflicting? I guess I'll just end on that by just saying, here's my personal conflict. One, I'm completely convinced we need a crime of ecocide. Two, to get it adopted, we need to figure out how to draw a circle around the kind of egregious behavior we want. There has to be some kind of bright line around it for states to say, yeah, I'm comfortable adopting that. And that's the trick that we're still working on, is what are the bright lines? This panel definition has taken one attempt at defining it, and I think it's pretty good, but maybe there's still something better still to be found. Maybe someone in this Zoom will be the one that comes up with the solution. Thank you.
Thank you, Professor Robinson, also for really sharing with us the difficulty behind defining ecocide, and also finding, first of all, understanding whether it's a good idea. And it seems that also from your understanding, it could boost somehow the role of international criminal law and international criminal justice as well. The importance of the forum. So ultimately the focus would have to be on the actual implementation. So domestic courts, international courts, yes, okay, but still let's focus on implementation. And then ultimately the definition and possible ingredients and also possible way forward. So let's see how the definition that has been drafted this year will evolve, and how also the international community will react to it. So thank you very much for your presentation. Now I would like to really end the second panel, and also thank you again to all the speakers. I would like to open the floor to questions from the audience. Feel free to write possible questions in the chat, or ultimately feel free to also just click on your camera and go live in the Zoom. Otherwise, I will just abuse my role eventually. Let's wait a minute. Okay, so we have a question in the chat from for John Scallon from Elena Fazoli. Thank you very much. And she's asking, since amending CITES does not seem a viable option, could adopting a new protocol to the Palermo Convention, but specifically dedicated to illegal traffic in wildlife, be an option?
Thanks for the question. And the Palermo Convention and having a protocol to it will really tackle the illicit wildlife trafficking aspects here, rather than directly address the issue of lawful trade. So the amendments to CITES were intended to address the currently lawful trade and currently unregulated trade. At the moment, CITES only regulates trade looking at it from a biodiversity and a trade perspective. It takes no account of the implications for public or animal health. So the idea of amending CITES is to say that the convention would oblige states prior to authorizing a trade to consider not just the biodiversity implications, but also the public and animal health implications. It would also allow species to be listed under the convention where their trade could pose a risk to public or animal health. At the moment, you can only bring a species under CITES trade control based on biological and trade criteria, not public or animal health. Under the Palermo Convention, it's more about tackling the trade that is illegal. So trade that is not undertaken in accordance with international or national law. There would be public and animal health benefits because obviously illicitly trafficked wildlife does not go through any controls to determine what the implications of that are from a public or animal health perspective. So it'll be picking up on that side of things. So one part looking at the illicit trafficking side, the CITES side was looking at the legal and currently unregulated trade side.
Thank you so much. We also have actually a question from Derry Robinson, Professor Robinson, to you, Mrs. Scanlon, and is on the draft treaty that you were mentioning before, whether it is available. So this is what Professor Robinson is asking.
Thank you. Yes, so we have a dedicated website for the Global Initiative to End Wildlife Crime. The initiative is hosted out of ADM Capital Foundation in Hong Kong, SAR. And we work with a law firm and a number of experts, including Tanya, who I think is still online here. Yeah, Tanya Wyatt. Worked with a number of experts to prepare a first draft. It's just a first draft of a potential protocol to help advance the conversation, because when we were speaking with a number of states, they liked the idea, but they said, could you give us a sense of what the content might look like? So that's available online. It's available in 7 languages, including English. And we also have posted online a number of answers to frequently asked questions. So since posting the protocol online and doing a number of events similar to this, we had a number of questions come our way and we've posted those online. So all available on the End Wildlife Crime website, and hope you find it of interest.
Thank you. And I think also Tanya now just included a link on the chat. So it's the certainly interesting, important for the last question. Other questions, someone from the audience who would also like to intervene live. There is a Jorge that has his hands up, so feel free to go live. Yeah.
Thanks, Ginevra. So essentially, I have a question that is a bit cross-cutting for more than one panelist. I'm not sure exactly to whom address it, so I'll just address it to all of you and see what we can pick up in the discussion. My view of how we could go about not just trying to intervene from a policy perspective on regulating crimes that have a disproportionate effect on the environment is that you would need first to do what's slowly starting to be done in the area of energy, for example, which is to identify what some people call acupuncture points, some other people call sensitive intervention points, some other people call leverage points. Essentially, you have a complex system. In that system, touching certain very specific points, either positively or negatively, will send that system into a certain trajectory. And what you want to do is to identify, this is, as Tanya was saying, essentially, if you have a systemic view of what crime is doing to the environment, what you want to identify are situations where there is this very negative or very positive point because it has a nonlinear effect. Now, from the perspective of biodiversity, we're not yet there. We're not yet there. We're not yet there even in planetary boundaries, although we're trying to identify what tipping points, that's another name of the negative nonlinearities. But from perspective of biodiversity, we're not yet there, but we have good candidates. I mean, John has been speaking about wildlife trade, and that's something very important. Dario, actually, when Dario was saying we need to find clear lines, the problem is in environmental law, there are no clear lines, that's simple, but you do have clear examples. So the fact that you don't have clear lines in environmental law doesn't mean that you don't have clear lines in environmental practice. So in short, for example, the reason why Roberto Ago developed in 1976 and included a crime, a state crime on massive pollution was because of nuclear tests. So you can identify a number of specific situations that would pop up. Now, would those be part of the sensitive intervention points or leverage points or acupuncture points? So I guess that we would need that research. We have a clear picture of at least some of them. I think that wildlife traffic, illicit wildlife traffic, not just for the CITES species, but as John was saying, for a wider range of species, that would be one very interesting angle. But there are many others, and we don't have a clear scientific picture. And what I'm trying to gather from the speakers is what would be the candidates.
So who would like to start? Probably as you prefer. We can start with the first panelist, or probably I would see it more for the second panel. So perhaps John Scanlon, Tanya Wyatt, and Derry Robinson. So John, you can start. Yes, if you.
I've already had a chance to answer a number of questions, so I want to give some of my colleagues a chance to go.
I'll take a crack. Yeah, that was one issue we encountered when we were trying to define a crime of ecocide, because one possible approach in international definitions is to put a list of conduct, examples of conduct. And again, it turned really hard because it's hard to find things that are even prima facie prohibited in international environmental law. So we had the stuff: biodiversity, trade in endangered species, traffic in hazardous waste, release of toxins into the air or ground or water. But it was really difficult because nothing is like firmly prohibited. And in fact, just one example is with the trade in species, we had written it in and we copied the trade in endangered species treaty. So we talked about affecting populations. And then today, John Scanlon points out that that would have been too narrow because we would have followed the existing rules, and then we wouldn't have covered trade in endangered species that could cause harms to health. So there's actually a movement away from even trying to list acts because of this problem, and trying to instead define a harm threshold. But it's yeah, incredibly difficult trying to blend criminal law and environmental law.
Thank you. Tanya, would you like to add something, perhaps?
Well, the question in the chat actually had me thinking, I wonder if we should be reversing this discussion as well and be listing things we can do rather than things that we shouldn't be allowed to do, and just perhaps being more creative and going for positive lists rather than these thresholds. Though I take Daryl's point about a harm threshold, I think there's probably some promise there, but that'd be difficult to get to. Yeah.
Thank you. Not sure whether others would like to add something. Otherwise, I would pass to probably the last question. So we have a question in the chat. From Alessio Azzariti for Alexandra Phelan. So if it can be difficult, he writes, if it can be difficult sometimes to regulate the zoonotic risk, I think that a possibility should be interpreting current human rights treaties, taking into account the scientific developments. Could this be a way to go beyond a positivist approach?
So Alessio has a wonderful piece on travel and the IHR, and using human rights interpretation for travel and the IHR. My Italian is very bad, but I was able to read a bit. And I think some of the approaches, Alessio, that you take in that piece definitely could apply. I think We have, those of us who work in infectious disease and human rights have, for a long time talked about how the IHR human rights provisions really aren't, expressly defined. There's no reference to what particular conventions or rights might be applicable. And there is a real push. There's a wonderful group with the Global Health Law Consortium and led by the International Commission of Jurists that are pushing for 10 human rights principles to go towards a pandemic treaty, really building out of some of the issues that arose with the IHR. I do think that gives us something more than a positivist approach, absolutely. And the challenge though with zoonotic risk is, human rights. We'd be looking at, say, potentially the right to health would be how we might be framing it, which expressly has epidemic diseases as a component. There's also a bigger question as whether we want to be using anthropocentric laws to be addressing challenges that are planetary health challenges and beyond. So I think there's certainly pathways for interpretation to help get us there, but I think this ties very closely to the points about planetary health boundaries as well. I think perhaps this is an opportunity for us to be thinking beyond the anthropocentric approach that human rights law does sort of bring us into. That being said, again, really loved your piece, and I think it's definitely something to explore.
Thank you so much, Alexandra, for your answer. So it's 7, at least where I am. Perhaps it's 6 in the UK, and of course, wherever you are, at different timing. I would like to end here, unless there are really questions that some others would like to add. Otherwise, thank you so much. I would like to conclude here. And certainly the recording of the conference will be available from next week on the ESIL YouTube channel. And also we will certainly share it soon on other social media. So thank you again. I really want to thank everyone for zooming in. Thank you also to our panelists for giving up their time for this event. It was really a wonderful discussion. And thank you also to this great audience for the questions. So come again, and I hope to see you all in person very soon. Have a nice evening or afternoon. Bye.
Thank you.
Thank you.
Bye-bye. Have a good weekend.
You
Cheers.
too. Bye-bye.